This is the Ministry of Truth. I'm Gordon Comstock. Time for Part 4 of Woe Unto You, Lawyers by Fred Rodell, out of print from 1939. Chapter 5, No Tax on Max. Quote, "If the law supposes that," said Mr. Bumble, "the law is a ass, a idiot," unquote. Charles Dickens. In case anyone should suppose that the exalted acme of the lawyer's art, known as constitutional law, cannot possibly be so unconvincing, so inept, so silly as a quick summary of Supreme Court logic perhaps makes it sound, it might not be too bad an idea to take one of the court's ukase. I'm not familiar with that word. U-K-A-S-E, ukase. About the Constitution and what it really means, and give that ukase, or opinion, a thorough going over. The subject of this little experiment in vivisection will be a case known to the lawyers as Senior versus Braden. It was decided by the Supreme Court in the spring of 1935. No, Senior versus Braden was not, of course, chosen at random. It is, for a Supreme Court opinion, mercifully short. It involves the court's favorite constitutional springboard, the good old Due Process Clause of the 14th Amendment. It reveals the court at its most legalistic, its most vacuous, its most unsubstantial, though for that purpose any one of 1,000 cases might have served equally well. Furthermore, Senior versus Braden was not a unanimous decision. It was a 6-3 decision, but the existence of a dissent in any case involving interpretation of the Constitution has been, for some time now, the rule rather than the exception, and the dissent, be it remembered, doesn't count anyway. The majority opinion is the law, the gospel, so much so that even the dissenting judges must accept it. As with Senior versus Braden, they have accepted it when the case is used as the basis of legal argument in the future. In short, Senior versus Braden is today an integral and respectable part of the law of the land as set forth by the top craftsmen of the profession. Here, then, interspersed with an almost literal translation of each paragraph into non-legal language, and with a few pertinent, or maybe impertinent comments, is the Supreme Court's opinion in Senior versus Braden. Hang on to your hats. Quote, January 1st, 1932, Tax Listing Day, Section 5328-1. The Ohio General Code provided that all investments and other intangible property of persons residing within the state should be subject to taxation. Section 5323 so defined investment as to include incorporeal rights of pecuniary nature from which income is or may be derived, including equitable interests in lands and rents and royalties divided into shares evidenced by transferable certificates. Section 5638 imposed upon productive investments a tax amounting to 5% of their income yield, and Section 5389 defined income yield so as to include the aggregate income paid by the trustee to the holder, etc., ... unquote. Parentheses. Under Ohio law, anyone who lived in Ohio and owned stocks or bonds or such had to pay a tax of 5% on the income from them, even if he got the income through a trustee or keeper of the property for him. End parentheses. Quote, appellant owned transferable certificates showing that he was beneficiary under 7 separate declarations of trust and entitled to state portions of rents derived from specified parcels of land, some within Ohio, some without. On account of these beneficial interests, he received $2,231.29 during 1931, ... unquote. Parentheses. The man who brought this case up to the Supreme Court, and by way of introduction, through no courtesy of the court, meet Max Sr., had some pieces of paper showing he had a stake in 7 plots of land in Ohio and elsewhere. His stake was worth over $2,000 to him in 1 year. Quote, the tax officers of Hamilton County, where appellant resided, threatened to assess these beneficial interests and then to collect a tax of 5% of the income therefrom. To prevent this, he instituted suit in the Common Pleas Court. The petition asked that Section 5323 General Code be declared unconstitutional and that appellees be restrained from taking the threatened action. The trial court granted the relief as prayed. The Court of Appeals reversed, and its action was approved by the Supreme Court, unquote. Parentheses. The local tax collectors, one of whom, incidentally, was named Braden, tried to get $100-odd out of Max. He, through his lawyer naturally, claimed the Constitution protected his $100-odd, took the case to court, and got licked. So far. End parentheses. Quote, with commendable frankness, counsel admit that under the 14th Amendment, the state has no power to tax land or interests in land situate beyond its borders, nor has it power to tax land or interests in land situate within the state in any other manner than by uniform rule according to value. Consequently, they say, if the property of appellant, which the appellees seek to tax in this case, is land or interest in land situate within or without the state, their action is unconstitutional and should be permanently enjoined, unquote. Parenthesis. The lawyers for the state of Ohio say, with a sort of double dare in their tone, that if the court should by any chance call this a tax on land, then they give up. They know that the court won't let Ohio tax land in, say, West Virginia, that any such attempt would be labeled a taking of property without due process of law in violation of the 14th Amendment. And, still with a double dare, they're willing to throw up the whole case and admit that Ohio can't even tax Ohio land in this way, if this is a tax on land. Notice, incidentally, that here, in a rather casually phrased reference to some of the lawyers' arguments, is the only mention of the 14th Amendment in the whole opinion, end parentheses. Quote, the validity of the tax under the federal Constitution is challenged. Accordingly, we must ascertain for ourselves upon what it was laid. Our concern is with realities, not nomenclature. Moffitt v. Kelly, 218 U.S. 400, 404, 405. McAllen Company v. Massachusetts, 279 U.S. 620, 625, 626. Educational Films Corporation v. Ward, 282 U.S. 379, 387. Lawrence v. State Tax Commission, 286 U.S. 276280. If the thing here sought to be subjected to taxation is really an interest in land, then by concession the proposed tax is not permissible. The suggestion that the record discloses no federal question is without merit, unquote. Parenthesis. This is a serious matter because somebody brought up the Constitution. Therefore we, the Supreme Court, are going to have to make up our own minds whether this is a tax on land or not. As we've said at least 4 times before, and if you don't believe us, here's where to look it up. You can't fool us with words. We want to know what's really going on. But if we decide this is a tax on land, then we don't have to bother to make up our own minds whether the Constitution forbids it. We're perfectly willing to take the lawyer's word on that little matter. And incidentally, the idea that this might not be any business of ours at all is beneath serious consideration. End parentheses. Quote, 3 of the parcels of land lie outside Ohio, 4 within. They were severally conveyed to trustees. The declaration of trust relative to the Clark-Randolph building site, Chicago, is typical of those in respect of land beyond Ohio. The one covering East 6th Street property, Cleveland, is typical of those where the land lies in Ohio, except Lincoln Inn Court, Cincinnati. Each parcel has been assessed for customary taxes in the name of legal owner or lessee according to local law, without deduction or diminution because of any interest claimed by appellant and others similarly situated, unquote, parentheses. To go back to Max Sr. and his profits, each piece of land he had a stake in was being kept and managed, for all the people who had stakes in it, by another fellow. Also, each piece of land had been soaked for the regular local property taxes, regardless of the fact that a lot of people were making money out of it, unquote. Quote, the trust certificates severally declare that Max Sr. has purchased and paid for and is the owner of an undivided 340 out of 1275 interest in the Lincoln Inn Court property, that he is registered on the books of the trustee as the owner of 5 out of 3250 of the equitable ownership and beneficial interest in the Clark-Randolph building site, Chicago, that he is the owner of 6 out of 1050 of the equitable ownership and beneficial interest in the East 6th Street property, Cleveland. In each declaration, the trustee undertakes to hold and manage the property for the use and benefit of all certificate owners, to collect and distribute among them the rents, and in case of sale to make pro rata distribution of the proceeds. While certificates and declarations vary in some details, they represent beneficial interests which, for present purposes, are not substantially unlike. Each trustee holds only one piece of land and is free from control by the beneficiaries. They are not joined with it in management. See Hecht versus Malley, 265 U.S. 144147, unquote. Parentheses. The legal language of the documents under which friend Max holds his stake in these plots of land all refer to him as the owner of something. He doesn't, however, own a little chunk of any of the plots in the sense that he could go and build a fence around it and sit there. He hasn't even anything to say about the way it's run. All he gets is his share of the profits when they come in. Our concern, remember, is with realities, not nomenclature. End parentheses. Quote, The state maintains that appellant's interest is a species of intangible personal property consisting of a bundle of equitable choses in action, because the provisions of the agreements and declarations of trust of record herein have indelibly and unequivocally stamped that character upon it by giving it all the qualities thereof for purposes of the management and control of the trusts. At the time the trusts were created, the interests of all the beneficiaries consisted merely of a congeries of rights, etc., and such was the interest acquired by appellant when he became a party thereto. The rights of the beneficiary consist merely of claims against the various trustees to the pro rata distribution of income during the continuance of the trusts, and to the pro rata distribution of the proceeds of a sale of the trust estates upon their termination, unquote. Parentheses. Ohio, out to collect its tax, claims that since Max not only can't put a fence around any of the land in question, but hasn't even anything to say about the way the land is run, he doesn't own anything but a chance of getting profits if there are any. Remember, our concern is with realities, not nomenclature. End parentheses. Quote, appellant submits that ownership of the trust certificate is evidence of his interests in the land, legal title to which the trustee holds. This view was definitely accepted by the Attorney General of Ohio in written opinions number 3640 and 3869, wherein he cites pertinent declarations by the courts of Ohio and of other states. See also 2 Cincinnati Law 255, unquote. Parenthesis. Max claims that since he has some pieces of paper and collects money on them, he must own something in the way of land, even though he admits that legally the fellows who run the land for him are supposed to own it. Some ex-Attorney General of Ohio once agreed with this idea in a general way and as applied to someone else. Accordingly, we must, remember, ascertain for ourselves upon what it the tax was laid. End parenthesis. Quote, the theory entertained by the Supreme Court concerning the nature of appellant's interest is not entirely clear. The following excerpts are from the headnotes of its opinion, which in Ohio constitutes the law of the case, unquote. Parenthesis. Even we, the Supreme Court of the United States, can't make much sense out of the legal language in which the Supreme Court of Ohio told what it thought Max Sr. owned. Try some of it yourself. End parenthesis. Quote, land trust certificates in the following trusts, the 7 described above, are mere evidences of existing rights to participate in the net rentals of the real estate being administered by the respective trusts, unquote. Parenthesis. What Max owns is nothing but the right to collect some of the profits. Not so hard, was it, after some of the U.S. Supreme Court's own language? End parenthesis. Quote, ascribing to such certificates all possible virtue, the holder thereof is at best the owner of equitable interests in real estate divided into shares evidenced by transferable certificates. Section 5323, General Code 114, Ohio Laws, page 17, does not provide for a tax against the equitable interests in land, but does provide a tax against the income derived from such equitable interests, unquote. Parenthesis. Still the Ohio Supreme Court talking. Even if we were to admit that Max does own something in the way of land, Ohio isn't out to tax whatever it is that Max owns. Ohio is taxing the income Max made out of it. End parentheses. Quote, apparently no opinion of any court definitely accepts the theory now advanced by appellees, but some writers do give it approval because of supposed consonance with general legal principles. The conflicting views are elaborated in articles by Professor Scott and Dean Stone in 17 Columbia Law Review, 1917, at pages 269 and 467, unquote. Parentheses. Back to the U.S. Supreme Court now. The state's idea that all Max owns is the right to get profits has never, so far as we know, been sanctified as the law by any court anywhere. Perhaps because, quote-unquote, we couldn't understand what the Ohio Supreme Court said in this very case. We admit that mere lawyers and law teachers have played with the idea, including one of our own august number, long before what he thought made any difference so far as the law was concerned. Note, too, the reference to general legal principles. End parentheses. Quote, McGuire versus Treffry, 253 U.S. 12, much relied upon by appellees, does not support their position. There, the Massachusetts statute undertook to tax incomes. The securities from which the income arose were held in trust at Philadelphia. Income from securities taxable directly to the trustee was not with the statute. The opinion accepted and followed the doctrine of Blackstone versus Miller, 188 U.S. 189, and Fidelity and Columbia Trust Company versus Louisville, 245 U.S. 54. Those cases were disapproved by Farmers Loan and Trust Company versus Minnesota, 280 U.S. 204. They are not in harmony with Safe Deposit and Trust Company versus Virginia, 280 U.S. 83, and views now accepted here in respect of double taxation. See Baldwin versus Missouri, 281 U.S. 586. Beadler versus South Carolina Tax Commission, 282 U.S. 1. First National Bank versus Maine, 284 U.S. 312, unquote. Parentheses. The state of Ohio has tried to throw our own words back at us by reminding us of a case in which we once said that it was perfectly all right for a state to tax a man who lived in the state on profits that came to him through someone who is keeping property for him in another state. But that case was really quite different. One of the differences was that in that case the tax was on income, and here, by pretty definite implication, the court seems to be saying for the only time in the whole opinion that the Ohio tax is not a tax on Max's income. Anyway, the controlling principles of that case don't control any longer, as we've said in several cases since. The principle that usually controls these days is that if we see anything getting taxed twice, it's probably unconstitutional. End parentheses. Quote, in Brown versus Fletcher, 235 U.S. 589, 599, we had occasion to consider the claim that a beneficial interest in a trust estate amounts to a chose in action and is not an interest in the res subject of the trust. Through Mr. Justice Lamar, we there said, unquote. Parenthesis. To get back to the real problem, which is what does Max Sr. own anyway, somebody else once asked us to decide as a general principle whether a man who makes money out of property that is being kept and managed for him owns only the right to get money, or whether he sort of owns some of the property. This is what we, meaning the 9 lawyers who then made up the Supreme Court, most of them now being dead, had to say. End parentheses. Quote, if the trust estate consisted of land, it would not be claimed that a deed conveying 7/10 interest therein was a chose in action within the meaning of Section 24 of the Judicial Code. If the funds had been invested in tangible personal property, there is, as pointed out in the Bushnell case, Bushnell v. Kennedy, 9 Wall 387393, nothing in Section 24 to prevent the holder, by virtue of a bill of sale, from suing the recovery of the specific thing or damages for its wrongful caption or detention. And if the funds had been converted into cash, it was still so far property, in fact, instead of in action, that the owner, so long as the money retained its earmarks, could recover it or the property into which it can be traced from those having notice of the trust. In either case, and whatever its form, trust property was held by the trustee, not in opposition to the cestui que trust, so as to give him a chose in action, but in possession for his benefit, in accordance with terms of the testator's will, unquote. Parenthesis. If a man with some land that was being held for him by somebody else should transfer part of his stake in the land to a third person, no one would be fool enough to claim that the piece of paper involved in the transfer was a chose in action. A chose in action being, roughly, a piece of paper that entitles its owners to certain rights, including usually the right to collect money from someone, in the sense that the words chose in action are used in one section of the federal statute that tells the federal courts how various kinds of lawsuits should be handled. If, instead of land, it had been goods or cash that was being held, and someone had swiped the goods or the cash, then the man with a stake in them could bring a lawsuit to get the stuff back. At any rate, whoever might have been holding the property for whoever had a stake in it would, in truth, have been holding the property for whoever had a stake in it. And just try to figure out what any of this, whatever it means, has to do with Max Sr. and the tax he doesn't want to pay. End parentheses. Quote, the beneficiary here had an interest in, and to, the property that was more than a bare right, and much more than a chose in action, for he had an admitted and recognized fixed right to the present employment of the estate, with a right to the corpus itself when he reached the age of 55. His estate in the property, thus in the possession of the trustee for his benefit, though defeasible, was alienable to the same extent as though in his own possession and passed by deed. Ham versus Van Orden, 84 New York, 257-270. Stringer versus Young, trustee, 191 New York, 15783. NE 690. Lawrence versus Bayard, 7 Page, New York, 70. Woodward versus Woodward, 16 New Jersey, Esquire, 8384. The instrument by virtue of which that alienation was evidenced, whether called a deed, a bill of sale, or an assignment, was not a chose in action payable to the assignee, but an evidence of the assignee's right, title, and estate in and to property, unquote. Parentheses. The man who is having some property held for him in this case, namely the case that had been decided 15 or 20 years before, owned something more than a chose in action. This fellow, as a matter of fact, had the right to any profits from the property that was being held for him, and also the right to take over the property into his own hands when he reached a respectable age. He also had a perfect right to sell his rights, and apparently he had done just that. The paper that represented the sale of these rights was not a chose in action. It was proof that the man who bought the rights now had certain rights in the property in question. End parentheses. Quote, the doctrine of Brown versus Fletcher is adequately supported by courts and writers. Narragansett Mutual Fire Insurance Company versus Burnham, 5-1, Rhode Island 371-154, Atlanta 909. Bates versus Decree of Judge of Probate, 131, Maine 176-160, Atlanta 22. Bogart, Handbook of the Law of Trusts, 430. 3 Pomeroy, Equity Jurisprudence, 4th edition, 1928, 975, page 2117. 17 Columbia Law Review, 269-289. We find no reason for departing from it, unquote. Parentheses. Judges and others from time to time agreed with the general principles just quoted, so do we. End parentheses. Quote, the challenge judgment must be reversed, unquote. Parentheses. Therefore, Max Sr., remember him, doesn't have to pay his tax. End parentheses. And that, finally we're done with that the legalese part of this chapter. Oh, man. If you're still listening, I congratulate you. All right, the rest of this chapter is not like that. I guess the author was just citing that to emphasize the asininity of legalese. And that, ladies and gentlemen, is the opinion of the Supreme Court of the United States in the case of Senior versus Braden. In order to find out what the Supreme Court was talking about, and also what it wasn't bothering to talk about in the case of Senior versus Braden, it is necessary to go back a little into the general principles of constitutional law that presumably controlled the decision. They start in the 14th Amendment, despite the fact that the 14th Amendment played very little part in the court's opinion. And, of course, they start in the Due Process Clause. The primary principle involved is to the effect that when a state tries to tax something which it has no jurisdiction to tax, that amounts to an attempt to deprive somebody of property without due process of law, inasmuch as jurisdiction means, loosely, power. Such a rule seems not too unreasonable. At least it seems not too unreasonable once you have swallowed the court's habit of using the 14th Amendment for other purposes than the protection of Negroes, and others against unfair criminal trials. But obviously that leaves it entirely up to the Supreme Court to decide what a state has power or jurisdiction to tax, and what it hasn't power or jurisdiction to tax. And in the course of deciding, the court has laid down a lot of sub-principles which give jurisdiction a special, if sometimes indefinite, meaning. The first sub-principle is that a state has no jurisdiction to tax land outside its borders, and that, regardless of what relation it has or hasn't to the 14th Amendment, seems eminently sensible and fair. It also seems eminently pointless. For New Hampshire, for instance, would no more try to slap a property tax on a farm in Iowa than the United States would try to tax a ranch in Argentina. There wouldn't be any way of collecting the tax, and no state would be idiotic enough to try. But starting from that fair, if pointless, principle, the court has gradually built up other principles about what a state has or hasn't, quote-unquote, jurisdiction to tax. A lot of property today, like stocks and bonds and IOUs and mortgages and trust certificates, is not so solid and stationary as land, and so occasionally different states try to tax that kind of property at the same time, and the owners of the property don't like it. The Supreme Court has obligingly enshrined in the law various complicated sub-principles telling which states have jurisdiction to tax that kind of property and which haven't. And these jurisdiction rules have been carried over with refinements and exceptions to other kinds of taxes than property taxes, especially to inheritance taxes. Where inheritance taxes are concerned, the court has laid down the principle that if two states try to tax the transfer of the same property at the death of its owner, then invariably one of the states has no jurisdiction to tax that transfer, even though the owner may have lived in one state and kept the property in another. This is what the Supreme Court was talking about in Senior v. Braden when it mentioned, quote, views now accepted here in respect of double taxation, unquote, and named several cases. All the cases named dealt either with inheritance taxes or else with the application of various sub-principles of the jurisdiction rule to property taxes on other kinds of property than land. The state of Ohio, not unnaturally, had assumed that all these cases had very little to do with the problem in Senior v. Braden. The state of Ohio thought it was arguing about an income tax, since the tax it was trying to collect from Max Sr. was computed by taking 5% of part of his income, and the Supreme Court had never before stretched any of its jurisdiction rules so far as to stop a state from taxing the income of someone who lived in the state. That is why the state of Ohio thought the case of McGuire versus Traffrey, which allowed an income tax very much like the tax on Max Sr., was, even though older, more to the point than all the inheritance taxes and property taxes the court named. The court, however, seemed to say that the principles of McGuire versus Traffrey were no longer controlling, because the inheritance tax and the property tax cases decided since then had made other principles more important, even for income taxes. But as a matter of fact, the court seemed to forget what it had decided in an even more recent case called Lawrence versus State Tax Commission, although the Lawrence case was actually mentioned in the opinion in another connection. For in Lawrence versus State Tax Commission, which dealt with an income tax, the principles of McGuire versus Traffrey had been followed as perfectly good law. In short, the court had held, even after laying down the principles that limited state jurisdiction to tax in the inheritance tax and property tax cases named, that it was quite all right and no violation of the 14th Amendment for a state to tax the income of someone who lived in the state. So in order to make any sense at all out of Senior versus Braden, the Supreme Court must have been saying that the tax on Max Sr. wasn't an income tax, but a property tax. And indeed, the court implied as much in its opinion and has said so definitely since. Now, as everybody knows, a property tax is universally considered to be a tax measured by the value of the property and collected every year whether the owner makes profits out of the property or not. The tax on Max Sr. was measured by his profits, and if there hadn't been any profits, there wouldn't have been any tax. But that little practical matter didn't stop the Supreme Court from calling it a property tax anyway. The court's excuse presumably was, parentheses, and notice how often you have to guess what the court means just to make its decision fit its own principles of law, end parentheses, that the Ohio legislature, in writing the tax statute, had inadvertently labeled it a property tax, even though it was measured by income. The fact that the Ohio Supreme Court had ignored this slip and treated the tax as what, practically speaking, it was, didn't faze the U.S. Supreme Court. Nor did the fact that it is strictly the business of the Ohio courts, and no concern at all of any federal court, to interpret the statutes of Ohio. For the U.S. Supreme Court blithely treated the tax as a property tax, meanwhile proclaiming, you remember, quote, our concern is with realities, not nomenclature, unquote. In constitutional law, a rose by any other name does not always smell so sweet. Even granting, then, with a gulp, that it was a property tax that Max Sr. didn't want to pay, why had Ohio no jurisdiction to collect it? For one of the cardinal sub-principles of the jurisdiction rule is that a state has, quote-unquote, jurisdiction to put a property tax on property owned by someone who lives in the state, if that property, instead of being land or goods, consists of pieces of paper, such as stocks or bonds, which give the owner certain rights. And surely what Max Sr. owned was a few pieces of paper, called trust certificates, that entitled him to some of the profits from 7 plots of land on which he had no right at all to go build a fence or a house. There is at least no doubt that if Max had bought, instead of trust certificates, shares of stock in a corporation that managed plots of land, just as the trustees managed the plots Max had a stake in, then the state of Ohio could have taxed those shares of stock without the Supreme Court raising a finger to stop it. What difference? The difference, and the only difference, is in the legal wording of the pieces of paper that did give, or might have given, Max a right to share in the profits. If he had held shares of stock, he would have been nothing but a stockholder. But since he held trust certificates, he was, in legal language, a, quote, cestui que trust, unquote. And being a cestui que trust, I hope I'm pronouncing that correctly, which only means someone who trusts someone else to hold property for him, Max Sr. claimed that he was, in a sense, the owner of some of the land that was being held for him. He claimed he was the owner of land, despite the fact that he had no right whatsoever to build a fence on the land or to manage it, but only to collect some of the profits. If it was land that Max owned, some of that land being outside Ohio, and if the tax the state was trying to collect was a property tax, then, argued Max, Ohio has no jurisdiction to collect the tax. For by the very first sub-principle of the jurisdiction rule, a state has no jurisdiction to tax land outside its borders. And so, at long last, appears the question to which the Supreme Court devoted almost its entire opinion in Senior versus Braden, taking the problems and principles discussed thus far almost entirely for granted. The question was this: does Max own land, or does he merely own the right, written on some pieces of paper, to get some of the profits from certain plots of land that are being held by somebody else? In seeking the answer to this question, the court, despite its vaunted, quote, concern for realities, unquote, paid no attention whatsoever to the practical setup of the business arrangement under which Max Sr. had collected $2,000 in 1 year. Instead, the court looked back to an old Supreme Court case of almost 20 years before in order to find a general principle. The case was Brown versus Fletcher, yet it happens that the problem presented and solved in Brown versus Fletcher had not the remotest relation to the 14th Amendment, to taxes on land, or to taxes on anything else. The problem of Brown versus Fletcher was purely a problem of the proper legal procedure in the federal courts under the federal statute governing such procedure. The statute denied the privilege of bringing suit in the federal courts to certain, quote, assignees of choses in action, unquote, or people to whom had been transferred pieces of paper entitling their owners to certain rights. The central character of Brown versus Fletcher claimed that a piece of paper that had been transferred to him was not a quote-unquote chose of action, and that he was privileged to sue in the federal courts, parenthesis. His piece of paper, incidentally, though something like Max Sr.'s trust certificates in its legal language, gave him many more rights than Max Sr. ever got from the trust certificates. In parentheses. The Supreme Court agreed that the paper was not a quote-unquote chose in action, and that its owner was entitled to bring suit in the federal courts. And that was all Brown versus Fletcher amounted to. In the course of deciding this, the Supreme Court wrote the two long and rather incomprehensible paragraphs that were quoted verbatim in the Senior versus Braden opinion. And it was on the basis of those two paragraphs, as expressing a relevant general principle, that the Supreme Court of a generation later concluded that Max Sr. did, in a sense, own land, and so could not be taxed by the state of Ohio. Thus, the reasoning of the court in Senior versus Braden boils down to something like this. The 9 judges who held our jobs almost 20 years ago in deciding a problem of federal court procedure expressed the general principle that certain pieces of paper giving their owner certain rights were not technically, quote-unquote, choses in action. Therefore, what Max Sr., whose trust certificates read something like those pieces of paper, really owns is land. Some of that land is outside Ohio. Ohio is trying to tax some of the profits Max Sr. made out of his stake in that land. The tax, even though it is measured by the profits so that it works like an income tax, is called a property tax in the statute. Therefore, it is a property tax. Since it is a property tax, it is a tax on what Max Sr. owns. But what Max Sr. really owns is land, some of it outside Ohio. Therefore, Ohio is trying to tax land outside Ohio. But we have a principle that no state has jurisdiction to tax land outside its own borders. we also have a principle that a state tax on something which the state has no jurisdiction to tax deprives the taxpayer of his property without due process of law and violates the 14th Amendment. Whew. Wow. This is, I'm sure, the most boring ministry of truth you've ever listened to. The most boring show I've ever done. But, and I apologize, but the reason this chapter is this way is because Fred Rodell is illustrating how absurd and asinine and circumloquacious, is that the right word? How nonsensical, how Byzantine, labyrinthine is all of this legalese garbage that these men and now women in black robes are dealing in. It's a game. It's a high-sounding, highfalutin game that they play on us. And it amounts to holding power over us with, it's like Fred Rodell started with, the medicine men of the Middle Ages, the medicine men of ancient times and the priests of Middle Ages. It's smoke and mirrors. There's nothing there. It's like our money. It's like Federal Reserve notes. There's nothing there. There's nothing backing it. Or electronic digits with money nowadays. This is all garbage they're talking about, and it makes no sense, but it just wastes a lot of time and wastes a hell of a lot of words. Just attack of verbiage. Somehow, I can't see Moses in, was it in the book of Joshua or the book of Exodus, where Moses was judging judging cases, basically, between his people while they were on the way to the Promised Land. And then Moses' father-in-law had the wise counsel to tell Moses to get a few elders, a few wise elders to take over and help Moses with the job of judging between the contentions between the people. Well, nevertheless, somehow I just can't see Moses wasting all of this verbiage, wasting this time with this labyrinthine language of confusion. Of course he didn't do that. We're dealing in a completely different style of law. Fred Rodell is illustrating the absurdity of Babylonian law, basically. And of course Moses, that was the Lord's law. All right, back to the book. Oh, this is exhausting reading this, so it's probably exhausting for you to listen to it. But I wanted to present the book in its entirety. So, again, I apologize for the just the ponderous nature of this. Okay, continuing. Therefore, Ohio's attempt to collect a tax from Max Sr. is forbidden by the Constitution. Therefore, Max can keep his $100-odd. Nor, if you can hold on just a little longer, is that all there is to Senior versus Braden. Although it is all that can be explained, even by the circular, irrelevant abstractions of legal logic. For Max was allowed to keep every cent of the $100-odd that Ohio was trying to take from him in taxes. Yet, part of the land that Max had a stake in was not outside Ohio at all. It was inside Ohio. So even if it was a property tax, and even if what Max owned was really land, why couldn't Ohio tax the land inside its borders? What was unconstitutional about that? There isn't even a legal answer. The Supreme Court's jurisdiction principles under the 14th Amendment allow, as they would obviously have to allow, a state to tax its own land. True, The Ohio land that Max had a stake in had already been taxed once that year under a regular property tax. So, considering the tax in the case as a property tax, that made 2 property taxes on the same land. But there is nothing in the Constitution that forbids a state to do that if it wants to. There is not even a Supreme Court principle that forbids it. The courts rule against double taxation, applying only to taxation of the same thing by 2 states. The Ohio Constitution might well have forbidden it, but the job of saying what the Ohio Constitution forbids or doesn't forbid is, in legal tradition, exclusively the job of the Ohio courts. And the Supreme Court of Ohio has said that, so far as it was concerned, the tax on Max Sr. was entirely constitutional. Of course, there was that double dare of the state's lawyers in the case, to the effect that if the Supreme Court was crazy enough to call the tax a tax on land, then the court might just as reasonably throw out the whole tax. Apparently, what the court did was simply take the dare, despite the fact that there was not so much as a shadow of even a legal excuse for throwing out that part of the tax that applied to Ohio land. Thus, not only the inaccurate interpretation of a phrase of the Constitution, or the invoking of vague general principles about jurisdiction, or the dependence on tax nomenclature in the face of a contradictory reality, or the muddled language of a case about something entirely apart from the issue that was decided many years ago, not only any of these, but even the foolish bravado of a lawyer can serve as a foundation on which the Supreme Court may build a chunk of constitutional law. Here, in miniature, is the whole vast structure of sacred abracadabra that makes up the highest law of the land. And any non-lawyer with half a brain in his head, if only he could penetrate the smoke screen of legal language, would recognize the alleged logic not only of Senior versus Braden, but of almost any Supreme Court case you could name as nothing more nor less than an intellectual fraud. The fraud may have been more obvious in Senior versus Braden than in most, simply because the manipulation of legal lingo and logic was more inept and clumsy than usual. But even when the 9 master jugglers are working at their smoothest, it requires only a trained eye to see that those weighty thoughts they seem to be tossing around are in reality no more than balloons, full of hot air and easily punctured. And the worst of it is that the Supreme Court, like all courts and all lawyers, is all the time dealing with and settling practical problems. There was a very real problem in state finance involved in Senior versus Braden. By virtue of the court's decision, Ohio lost in revenue not only Max Senior's $100-odd, but the thousands upon thousands of dollars it would otherwise have collected as taxes from other Ohioans who had been making money the same way Max had been making money. Should Ohio then look to another kind of tax to make up the lost revenue? Or should it amend the old statute, call the tax an income tax this time, and hope that the Supreme Court, 3 or 4 years later, when a case gets that far, will be impressed by the label and hold the statute now constitutional? Regardless of the right answer, the court's solemn consideration of the type of property Max Sr. owned or didn't own seems scarcely pertinent to a solution of Ohio's or Max Sr.'s fiscal difficulties. Even if the court had snapped that Ohio was taxing legitimate investment too heavily and ought to cut down on its spending anyway, and that, therefore, the tax under dispute might not be collected, such a decision, though hardly judicial in manner, would at least have made a great deal more common sense than any discussion of, quote-unquote, choses in action, and interests in land, and similar irrelevant, ambiguous abstractions. Furthermore, the larger question which the court has been gaily disposing of, in the name of the 14th Amendment, under its general principles about state jurisdiction to tax, involves an extremely practical problem too. From the angle of the state governments, the problem is simply, now that the people and companies and property we have to collect taxes from in order to keep running are spreading themselves over a dozen or 48 states, as most of them are today. How are we supposed to keep up with them, and what kind of taxes can we impose on them without either chasing them out of our reach entirely, or else going so easy on them that we don't collect enough money to keep going? From the angle of the taxpayers, whether people or companies, the problem is simply, just because our business or our property spreads over a lot of states, is it fair or right that every one of those states, or most of them, should soak us with the same kind of taxes so that we have to pay tribute a dozen times for doing or owning one thing, whether it is income taxes, property taxes, or inheritance taxes that are involved? The basic practical problem is the same. Toward the efficient solution of that problem, the Supreme Court's jurisdiction principles contribute literally nothing. A categorical statement that the 14th Amendment denies to any state but the state of domicile, parenthesis, what is domicile? Who is she these days, end parenthesis. The quote-unquote jurisdiction to impose an inheritance tax on the transfer of intangible property, parenthesis. When is intangible property not intangible, as with Max Sr.'s trust certificates, end parenthesis, may sound very learned, as may the rule that acquisition of a business within a state by intangibles gives even a non-domiciliary state, quote-unquote, jurisdiction to tax. But neither the formulation nor the application of such principles, and their sub-principles, and their exceptions, sheds even the dimmest light on the basic difficulties of the state governments and the taxpayers. The fact is that the Supreme Court has neither the power nor the ability to find, for the problem in government here involved, a thorough or intelligent or workable solution, which fact does not bother the court in the slightest degree. It just goes merrily on laying down and applying its silly little abstract rules about quote-unquote jurisdiction to tax, and giving each of those silly little rules as much potency and prestige as if it had been adopted by the people as an amendment to the Constitution. As in Senior versus Braden, so in all the quote-unquote jurisdiction to tax cases. The meat of the real problem is passed by. The law sinks its teeth into the fluff of abstract logic. As in the quote-unquote jurisdiction to tax cases, so in all the cases under the quote-unquote due process clause of the 14th Amendment. As in the cases under the quote-unquote due process clause of the 14th Amendment, so in all constitutional law. As in constitutional law, so in all the lesser branches of legal learning. So in the whole of the law. And only the solemn and mystifying mumbo-jumbo of legal language keeps the non-lawyers from catching on. For instance, the citizens who directly and indirectly voted the 14th Amendment into the Constitution to protect the rights of the Negroes just after the Civil War might be a little surprised to learn that under the law they had forbidden the state of Ohio to collect a tax of $100-odd from Max Sr. Well, another thing these citizens, another thing they would be surprised to know is that the 14th Amendment was the totalitarian takeover of the country from the Rump Congress in the North, and that it really wasn't voted in. It really wasn't lawfully ratified. It was shoved down the throats of an unwilling populace and electors. And they threw out several senators unlawfully. They threw out all of the southern states. 2 years after the so-called Civil War ended, and the southern states, they passed the 13th Amendment. I mean, they came back in peace. They're part of the country again. All is well. Then all of a sudden, oh no. A rump Congress in the North, in the back pocket of the bankers, the international bankers, in the back pocket of the London Bank, in the back pocket of the Vatican, etc., etc. So that 14th Amendment, yeah, Fred Rodell doesn't know that sordid history, but he knows about the chicanery of the law. He can actually read through this garbage, this legalese. Man, I think he studied law, but then he repented, is what I think I remember reading, something like that. Anyway, I'm Gordon Comstock. This is the Ministry of Truth, and you were listening, if you got this far, you were listening to Part 4 of Woe Unto You, Lawyers by Fred Rodell from 1939. It's out of print, and that's almost assuredly not accidental. The rest of the book is not so incredibly tedious as this one chapter. So we'll get back to some more interesting stuff next time. Okay, thanks for listening. God bless. Bye-bye.